It's now shortly after 7 p.m. I'd like to go ahead and get this April 11th, 2019 Board of Adjustment meeting started. Ms. Elliott, would you please take the roll?
Kathy Montrose.
Present.
Stephen Currituck.
Present.
Tom Roddy.
Present.
Gregory Hammer. Corey Breathwaite.
Present.
Lynn Hicks.
Present.
Okay, so it appears we have a quorum of 4 regular members and 1 alternate. Mr. Lynn Hicks will be sitting in as a member of the board tonight. All right, I'm going to move to the approval of the agenda. Do I have a motion? Do we have any changes to the agenda?
Mr. Chairman, I'd like to make the change that the oath of office be removed because it has already been performed, and make a motion to approve the agenda as amended.
Do I have a second?
Second the motion.
All right, all in favor say aye.
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 All opposed say nay. All right, motion carries. I'd like to go into the approval of the minutes from the January 10th, 2019 meeting. Are there any changes to the minutes from the January 10th meeting? All right, hearing none, do I have a motion to approve the minutes as presented?
Propose we approve the minutes as submitted.
All right, do I have a second?
I'll second the motion.
All right, all in favor say aye.
Aye.
Motion carries. I have a one quick announcement. If there's anyone in the audience that's wishing to speak tonight and who is not an applicant, I would ask that you please sign in to speak and indicate the case. There's only one tonight, so if you have not already done so, please do so when you get an opportunity. All right, at this time, I'm going to ask for disqualifications.
Mr. Chairman, I don't have a disqualification, but I would like to make a disclaimer that on April 29, 2016, my wife and I used the services of Hampton Lodge Campground and stayed one night with our camper. We arrived at 4 p.m. on that date and left the next day around 12 noon. And I do not believe that my participation there that day will cause any effect, positive or negative, about the decision-making that I'll perform tonight regarding this case.
All right. Ms. Womble, did you have anything you wanted to add at this point?
Not as to Mr. Craddock's disclaimer. There was one item I did want to note for the record. I've already discussed this with the attorneys for all present tonight. But my firm, the Twyford Law Firm, is previously John Morrison represented and assisted Lucky Pappas. He is the prior owner of the Hampton Lodge Campground. I have spoken to Mr. Pappas. He is here. He had no objection to my involvement here tonight, as did none of the attorneys involved, Mr. Tom Johnson, Ike McCree for the county, and Mr. Tom Nash. None of the other attorneys had an issue with my participation. I also consulted with the State Bar regarding my involvement, and again was confirmed I did not have a conflict. I did want to disclose that, such that if there was any discussion in the community or about that, the Twyford Law Firm previously was involved with the prior owner. I wanted to make everyone aware, but there was no objection.
Okay, thank you. Moving on to old business. Is there any old business that needs to be attended to tonight? All right, hearing none. Ms. Elliott, do we want to go to the swearing in at this point?
Well, I think just if I could interrupt briefly, I think before we get to the swearing in of the witnesses, we need to address the Water Lily Association's motion to intervene that was filed. And let me just flip to where I have that. I believe that the attorneys previously discussed this issue, and that we're all in agreement that the Water Lily Association can participate under the provision in the ordinance that an affected party may present evidence and question witnesses. However, the applicant is going to reserve their objection relating to formal legal standing to be an official party to be involved if in event there is further litigation from this point. And if I did not state that correctly, please, any of the attorneys
Yeah, this is Tom
comment.
Johnson from Williams-Mullen on behalf of the appellant. And yes, I agree with that. We would reserve our objection with respect to standing, which I understand the rest of the parties were fine with doing that. And yes, I know under the ordinance there's an opportunity for those that are affected to participate, which Mr. Nash is representing that group of individuals. So we're fine with that.
Okay. All right. Is there anything further that Mr. McCray?
No,
or
this
Mr.
is Tom Nash, and I'm fine with that. I understand he's reserving his rights if this thing goes further. We will put on evidence tonight.
Okay, thank you.
I think that resolves that issue, so I think you can go ahead and proceed to swearing witnesses.
Okay. If you are representing any of the applicants or want to speak on any of the cases tonight, please come up and be sworn in. All right, so we're doing a group swearing in, so we'll, if each of you would state your names for the clerk. You can do that in unison, if you like. And place your left hand on the Bible and raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? I do. All right, thank you. Okay, so we have one case on the agenda tonight. It's BOA 19-02, Hampton Lodge Campground. Williams-Mullen is appealing a letter of interpretation dated January 7th, 2019, on behalf of property owner 85 and Sunny, LLC, for a non-conforming campground located at 1631 Water Lily Road in Coinjock. And at this time, I'd like to ask the staff to present their case.
Yes, Mr. Chairman, the county will call Planning Director Laura LaCicero. I think we're going to have witnesses, as I understand it, sit over here to answer questions from attorneys.
Okay.
Excuse me just a minute. Lauren, were you going to summarize? I understood that you were going to
Sure.
summarize what we're here for in the
Sure. And
quasi-judicial
I
and
did,
that sort of thing. I think it'd be helpful to the
Okay.
audience and the board.
so, and I did speak to the chair about that previously. So to the board, this is many of your first meetings here with the Board of Adjustment, and particularly maybe your first quasi-judicial proceeding. And so I just did want to briefly discuss that. Your prior representation, Ben Gallup, did a little bit of training with you in January when he stepped down. I did review his video, the presentation, and I would concur with his training that he gave you and his statement of your role and how the procedure works and what you will be deciding. Just briefly for you and for the public, tonight this is a quasi-judicial hearing, so you are sitting as a judge. You have to sit as an impartial decision maker. That's why we asked about the disqualifications, and Mr. Craddock put that disclaimer to say that his attendance at Hampton Lodge was not going to interfere with his ability to make an impartial decision. So you're sitting as a judge, and you have to consider the evidence that is presented to you tonight to make your decision. And ultimately, you're going to take the facts as they're presented and apply the law, and that's the ordinance in Currituck County. Everyone's already been sworn in, so this is, all testimony has to be under oath, and it has to be relevant evidence, a little bit different than just a public comment period where citizens can come and present on any issue they feel moved about, but ultimately the testimony has to be relevant to the issues that are presented to the board. Mr. Braithwaite already covered what you're here for tonight. I was going to cover that, but you are reviewing the determination that the planning director made in this matter. So that's kind of just my brief summaries. I would just concur with what Mr. Gallup already told you. I think that's all I had.
State your name and how you're employed.
My name is Laurie Lou Cicero, and I am the Currituck County Planning and Community Development Director.
And Ms. Cicero, in that capacity, did you receive a request for interpretation of, and determination of certain requirements of the Unified Development Ordinance from the applicant 85 and Sunny?
Yes, I did.
And what was the nature of that request for interpretation or determination?
In their letter, in their application, they wanted me to determine the number of campsites that existed at Hampton Lodge on January 1st, 2013. And they also wanted me to determine whether modifications to the Hampton Lodge shown on their site plan that they submitted in the summer of 2018 were permitted. And also that referenced that site plan from the summer of 2018.
Now, what is Hampton Lodge?
Hampton Lodge is a campground located at the end of Water Lily Road in Coinjock.
Is there any other name by which this property is known, or for purposes of this hearing, you'll be using the term Hampton Lodge?
Hampton Lodge Campground. And those are probably the two that I'll be using most frequently.
And you received that request for interpretation or determination on or about August 30, 2018, is that correct?
That's correct.
And upon receipt of that letter of interpretation or determination, what did you then do?
I started going through the documentation of the county to determine to research and try to find the answer to the applicant's questions.
Okay, let's then start again with I guess historically, what were you able to determine from the county's records regarding Hampton Lodge, its existence originally and its existence up to the present time under the various county ordinances that have been adopted?
The first record that we have in the county as far as interaction with the county were some septic permits that were issued in May and June of 1967 and August of 1969. We have a septic permit application for a bathhouse and a septic permit for a trailer and a septic permit for 6 camper spaces in August 1969. And that was the first record that I had that we found for Hampton Lodge.
At that time, did the county have zoning or zoning ordinance in effect?
No, we did not have countywide zoning in effect. We did have it around that time, I think at some point in 1968, 1969, we had it for very specific townships. The township that Hampton Lodge is in was not part of that. We did not get countywide zoning until October 7th, 1971. And once that was adopted, the Hampton Lodge campground was zoned recreational residential was the zoning district it was in.
So what requirements were there in the October 7, 1971 zoning ordinance relative to campgrounds?
Campgrounds were a permitted use in that 71 zoning ordinance, but they did have some requirements. They were required to submit a preliminary plat to the planning board with each camp application for tent sites and camping trailers. They were required to have a minimum of 6 acres of land. Each each campsite had to measure 3,000 square feet. There was a 200-foot setback for buildings, tent spaces, and trailer spaces from any property line maintained as a natural buffer. A maximum distance of 400 feet were required from drinking water and toilet facilities, a maximum of 1,500 feet distance to wash houses, and campgrounds are allowed in the floodplain district with a conditional use permit with those same regulations.
Were you able, in your review of county records, were you able to find any documentation or records that the owners of Hampton Lodge Campground at that time complied with the requirements of the 1971 zoning ordinance?
In the documentation, I could not find that they submitted any of the information to verify that they met those requirements.
And so did you then determine whether they would be deemed a conforming or non-conforming use in 1971?
Because I couldn't find any documentation, I would say that they would be a non-conforming use even in 1971.
Okay. As you continue to look at the historical record of the county, what did you then review and determine relative to the Hampton Lodge Campground?
The next instance I found of Hampton Lodge in the county records were minutes from a March 20th, 1973 meeting of the Currituck County Board of Commissioners. At that time, Action Development, Inc. Requested the board, had a request before the board for a subdivision plat for Hampton Lodge. And there were an unrecorded plat that was part of that application, and we found that in the county's archives. And it appears that the Action Development, Inc. was seeking to create a camper subdivision. The Board of Commissioners at that time required installation of certain infrastructure, and that they would not approve that March 20th Board of Commissioners meeting. The board determined that the camper subdivision would not be approved until the posting of the required bond and compliance with all of the requirements and procedures of the Currituck County subdivision and zoning ordinance. Based on my research, we could not find that Action Development completed any of that process required for approval of the camper subdivision, so no further action was taken by the Board of Commissioners on the Action Development application.
So that application and plat were never approved?
They were never approved, and the plat was never recorded.
And do you recall approximately how many camper lots were shown on that particular proposed plat that was never approved?
I think well over 700 were shown on that plat.
All right, please continue with the next steps that you took in your review.
And for when the 1971 zoning ordinance was in effect, we did have a record of Hampton Lodge applying for and receiving numerous septic permits in April of 72, July of 70, in April, July, and August of 72. There were septic permit applications for up to camper sites 124. So camper spaces numbered 124. So the next, and also in May of 1973, there was another septic permit application. The next instance we found, the next thing was the Currituck County Commissioners enacted, changed the ordinance in 1975, and the official zoning map changes. And under this 1975 zoning ordinance, camping was also a permitted use of property only in recreation campgrounds located in the recreational residential, the RR zoning district. The Hampton Lodge was zoned recreation residential at the time in 1975.
Were there additional requirements in that ordinance for to become a conforming campground?
Yes, the additional requirements would have a minimum of 10 acres under single ownership with 3,000 square feet per camper space. Again, 8% of the total acreage had to be devoted to recreational area, and 50% of that recreational area had to be active recreation.
And was a campground use required to receive a conditional use permit as well?
Yes.
And were you able to find any documentation or evidence in the county's records whether Hampton Lodge campground owner at that time ever applied for or received a conditional use permit?
Yes, on October 29th, 1975, a conditional use permit was issued for Hampton Lodge by the Currituck County Board of Adjustment case, by the Board of Adjustment. But it wasn't for the entire site, and I think it started out, from the way the records show, it started out as an appeal of the code enforcement officer's determination to upgrade 12 waterfront campsites. And
Upgrade in what way?
by the addition of septic tank systems to provide sewer disposal for those 12 sites. They were going to upgrade those 12 sites.
And were you able to determine what action, if any, the Board of Adjustment took relative to that application?
Yes, they approved those 12 sites. But a condition of the Board of Adjustment's decision required a submission of a plat for the 12 campsites from the Currituck County Code Enforcement Officer, and the 12 sites must be in conformity with the 1975 zoning ordinance. And we do have a copy of that site plan. If we could move forward on the, I don't have the,
I have the clicker.
this is the site plan that we found in the records. And essentially, these 12 sites here were requested to be upgraded with septic disposal. Also in the site plan, there's indication that you had waterfront campsites that went all the way around here that numbered sites 23 through 101.
So at least as to that use permit issued on October 29, 1975, it related to the upgrade by addition of septic to 12 waterfront lots. Is that correct?
That's correct.
Right. And further identified, at least on that particular map, that there were up to 101 existing campsites at that time.
That's our best determination with the site plan.
Okay, what then did you learn during the course of your review?
Under that 1975 zoning ordinance, there were another septic tank permit application issued, and also we had building permit for electrical service to 14 campsites happened under that 1975 zoning ordinance.
Okay, did the county adopt another zoning ordinance there sometime after 1975?
Yes, in November of 1982, a new zoning ordinance and official zoning map, they were adopted. And once again, under the 1982 zoning ordinance, the RR30 residential recreation zoning district was created. And the RR30 district is described as containing some existing campgrounds and camper subdivisions and is retained for the purposes of regulating these existing uses. It is not intended that this district be expanded. Recreation campgrounds were still permitted in the RR30 district with a conditional use permit meeting certain conditions, the same 10 acres under single ownership, 3,000 square feet per camper space, and 8% of the total acreage be devoted to recreational area, and 50% of that recreational area had to be active recreation. We could not find any evidence in the county's documentation and the county's records that Hampton Lodge applied for or received a conditional use permit under the 1982 zoning ordinance. Under that 1982 zoning ordinance, building permits were issued in September of '83 to rewire existing campsites. In March of '84, new 200 amp service and rewire for 18 existing campsites. In June 1984, there was a building permit for new service at existing campsites and to rewire 26 existing campsites. And in December of '86, there was a building permit to upgrade a 200 amp waterfront.
And then following 1982, there was in the April 2nd, 1989 Unified Development Ordinance adopted, is that correct?
That is correct.
And what did that particular ordinance require with regard to campgrounds in Currituck County?
They required a conditional or in special use permit. Once again, the RR, the recreational residential district, was not intended to be expanded except in certain cases. And campground, existing campground and camper subdivisions shall meet criteria established for a special use, conditional uses. They had a certain density they had to stay under, and a use permit was still required. With the same 10 acres under single ownership, with 3,000 square feet per campsite, and once again, the 8% of the acreage be devoted to recreational area, and 50% of that acreage was to be held in active recreation. There is no evidence in the county records that Hampton Lodge applied for or received a use permit under the 1989 UDO. There was one building permit issued in February of 1990 for 200 amp electrical service on A lots.
Okay, and then in 1992, the county again amended or adopted a Unified Development Ordinance, is that correct?
Yes. And once again, they were the similar similar criteria for the 1992 UDO residential recreation zoning district. Once again, the same. It's not intended to be expanded, and private campgrounds were permitted use with a special use permit with a similar criteria: minimum 10 acres of single ownership, 3,000 square feet per camper space, 8% of the total acreage devoted to recreational area, and 50% of that to be held in active recreation.
And there's still the requirement for a special use permit, is that correct?
Yes, still a requirement for the special use permit.
And were you able to find whether the owner of Campton Lodge Campground at that time or thereafter applied for or received a special use permit for a campground?
Not for a campground, but in April of 1996, they were issued a conditional use permit for an outdoor concert for a special event. The Board of Commissioners was the first consideration. This action by the Board of Commissioners was the first consideration of land development requests other than building or septic permits for this property since 1975.
Well, was it truly a land development request, or was it something else?
It's something else. It's a use permit for a temporary use in order for the applicant to hold an outdoor concert on this property.
Okay, and to be able to find as part of the application whether there was a map of Hampton Lodge Campground and any indication of campsites at Hampton Lodge?
We did. We had another site plan submitted. It's here on the screen. And we were able to, this plan illustrated 234 campsites. Zoning permit was also required for this special event. And the plan associated with the zoning permit application also illustrated 90 vehicular parking spaces for the event on the grassed area on the west side of the gravel road in this area, I believe. This not a very good.
Just trying to clarify where she was showing.
The grassed area right in here. This is a.
Okay, and did that map also indicate any area set aside for tent campsite?
It indicated a general area right in here.
Is that actually labeled?
I believe it is labeled for tent camping.
Okay, and it appears to be delineated
Yes, there's just a little area that's been delineated with that dash line that we took to be tent camping. It's the only area we saw designated such a way. So in 1997, a similar temporary use permit, special event conditional use permit for the similar concert was issued with the same site plan submitted.
Okay, what did you then further find in the county records?
So, but then in January of 1998, the Board of Adjustment issued a decision on appeal of an administrative decision regarding the property. The code enforcement officer had determined that there were numerous additions made to campers in violation of the effective UDO at the time. In the record of that case, staff found a list of 32 campsites that had obtained permits for screened-in porches.
But that was not an application for a special use permit as required by the Unified Development Ordinance for a campground in Currituck County, was it?
No, it was not. It was just the next instance we found in the county records where Hampton Lodge was considered in any board action.
Okay.
Also, during the time that the governed by the 1992 UDO, there were in January of '95 numerous septic repair permits issued to Hampton Lodge.
All right, was there then another ordinance adopted in 2007?
Yes.
And what did that ordinance provide, if anything, with regard to campgrounds in Currituck County?
Once again, campgrounds were allowed in the residential recreation zoning district, and it was, once again, they were not, this zoning district was not intended to be expanded except in certain cases. But so they were required, once again, to have a special use permit with certain conditions, minimum of 10 acres under single ownership, 3,000 square feet per camper space, 8% of the total acreage be devoted to recreational area, and 50% of that acreage be active recreation. Maximum camper size and platform requirements were also listed.
Okay, and were you able to find any documentary evidence that Hampton Lodge owners at that time applied for or received a special use permit?
No, we did. We found no indication in our records that Hampton Lodge applied for or received a use permit under the 2007 UDO. We also did not have any evidence of septic or building permits that were issued during that time of the 2007 UDO.
Okay, and after 2007, was there yet again another Unified Development Ordinance adopted?
Yes, there was, and the famous January 1st, 2013 UDO was enacted, and when that UDO was enacted, private campgrounds were removed as a permitted use, and also the residential recreation zoning district was eliminated. So all existing private campgrounds at that point became non-conforming uses and subject to a special section of the UDO. And as a non-conforming, that became a non-conforming use, and so they became governed by Chapter 8 of our UDO with general standards and specific standards.
And that ordinance, of course, is still in effect now.
That ordinance is still in effect now.
Hampton Lodge Campground continues to be, is a non-conforming use, is that correct?
Yes.
Okay. And were you able to find at any time from 1971 until today that Hampton Lodge Campground, or the Hampton Lodge property used as a campground, has ever been a conforming use in Currituck County?
No, since 1971, they did not follow through any action that brought them into conformity with the county's either zoning ordinance or unified development ordinances.
Okay, now, as you went through all that documentation, were you then able to determine to your satisfaction the number of electrical and/or septic permits that had been issued for the Hampton Lodge campground property from, what, 1967 until the present time?
We came up, when we counted, we came up with the 190 septic and electrical permits that are establishing 190 campsites through those permits.
And what else did you do in terms of coming to a conclusion satisfactory to yourself about the number of, we'll say, first of all, recreational vehicle campgrounds or campsites or improved campsites?
Since we were very limited on the actual site plans that were submitted by Hampton Lodge in any case, throughout the history since 1967, the best case we had is the 1996-1997 site plan that established 234 campsites for recreational vehicles that was submitted as part of the temporary special use for the concert held on this property.
Okay, so you then concluded in your letter of determination that there were 234 recreational vehicle or improved campsites, is that right?
That is correct. That was my determination.
Now, there's also was a question with regard to the number of tent campsites. Is that correct?
That is correct. We did not find specific tent sites designated. We only found an area that was designated for tent camping, and not the 3,000 square foot campsite designation delineated for tents.
Okay. Did you happen to have you had a visit to Hampton Lodge Campground?
Yes, I went visited in June of 2018. Here's the picture of the area that was designated at that time as tent area camping.
And how was that area designated as tent area camping?
There were a few picnic tables, a sign on a tree that said tent camping, a few water spigots in there, best of my memory.
Okay, and where generally was that area located when you visited the property?
Close to where it's designated here.
Okay, here being the map, the plat that was submitted in 1996 and 97, use permit applications.
Yes, that's right. Right in there. And in the next, there's the road going through there and the campsites off there to the left.
Okay, did you see any similarly identified or set aside areas on the property that indicated to you tent camping was available or had occurred there?
I did not see any other areas designated that way.
And I believe in your letter of determination, you speak to the term campsite.
Yes,
That is not a term defined in the UDO, is that correct?
that is correct.
So, did you then take any steps to determine the definition of campsite?
I did. I reviewed the Planner's Dictionary published by the American Planning Association. This it's defined in that Planner's Dictionary as any plot, parcel, tract, or portion thereof intending for the exclusive occupancy by a camping unit. Then a camping unit is further defined as any tent, trailer, lean-to, recreation vehicle, or similar structure established or maintained and operated in a campground as temporary living quarters for recreation, education, or vacation purposes.
Okay, let me step back. I should have asked you first. If a term is not defined in the UDO, what then are you directed by Unified Development Ordinance to do in order to establish the definition for a term?
The The first step would be to consult the Planner's Dictionary or any other American Planning Association, similar publication that would define terms for planners.
Okay, and that, you're directed to do it in that manner by the UDO, is that correct?
Yes.
That's section 10.1.12.
Yes. Yes.
Now, as you toured the property, at least in June of 2018, were you able to determine whether there were any delineated sites that appeared to you to be intended exclusively for the occupancy of a camping unit, as you defined it, that being a tent, lean-to, recreational vehicle of the lot?
There were some delineated campsites on the property.
Other than in the area that you just described?
In the area, no, in this area that showed the tent camping, there were not delineated or designated tent camping sites. They were not numbered. There were no tent pads. Picnic tables and spigots were the indication that this was the water spigots were the indicator that this area was for tent camping.
Okay, and then in addition to that area, where else did you then see any indication of an area that was delineated or intended exclusively for occupancy of a camping unit?
Of a camping unit.
RV, a tent, lean-to, or
Whoops. Essentially along the waterfront and along the waterfront of the property and along the gravel road that ran throughout the property.
so consistent with this plat in the 1996-97 applications for use permit.
Yes, consistent with this site plan that was submitted in 96 and 97.
And upon which you made use and relied to come to your conclusion that there were 234 RV or improved campsites and perhaps an indeterminate number of tent sites, but at least they would be within an area delineated here as tent camping. Is that correct?
Yes.
Okay, I get, now then, so the first piece of your determination, you were requested to determine the number of campsites, correct?
Yes.
And then then you were asked to interpret a section of the nonconformity chapter, is that correct?
Correct.
Okay. And what was that section?
What modifications, the section would be existing campgrounds, and specifically what modifications would be allowed to an existing campground.
Okay. And what did you do as you made your determination as to what modifications would be allowed from the site plan submitted by the current owners of Hampton Lodge Campground, and how did you make that determination?
Yes, because Section 8.2.6, nonconforming campground, specifically says modifications to existing campgrounds are permitted, provided those changes do not increase the nonconformity with respect to the number of campsites that existed. Due to that and the definition of modification, I determined that a structure or a building needed to be already existing on the property in order for it to be modified, and they could only modify those existing buildings and could not add additional structures such as swimming pools, snack bars, tiki bars, things of that nature if a structure was not already on the property.
Okay, did you have to define then any term within Section 8.2.6?
I did have to define modification.
At 8.2.6A5, is that correct?
Correct.
Right, and did you utilize the same process as you're directed to by the Unified Development Ordinance to interpret or define a term that is not otherwise defined by the Unified Development Ordinance?
I did. The APA Planner's Dictionary did not define a modification, and the applicant had already, in the application, cited Black's Law Dictionary for the definition of modification as a change to something, an alteration or amendment. And I also considered the applicant's definition for modification found in Merriam-Webster's dictionary that defines modification as the making of a limited change in something. And so using those definitions, I determined that a structure needed to be existing in order for the structure to be changed.
Okay, and also in coming to the determination of what the term modification means, did you consider the intended purpose of that particular section of the UDO?
For the general or the specific?
Well, for Chapter 8.
For
both.
Chapter 8. Nonconforming, yes, I did. I chose both the general and the specific. Nonconforming uses, we want to phase them out over time, and so we do not want to make changes. Section 8.1.5, increase in nonconformity, except as authorized by the chapter 8. No person shall engage in an activity that increases in nonconformity. And then in section, put the wrong section, 8.1.6, minor repairs and maintenance. That section of the ordinance, minor repairs and normal maintenance that are required to keep a nonconforming uses structures in safe conditions are permitted, provided the minor repair or maintenance does not extend, expand, or enlarge the nonconforming aspect. So I would consider that keeping things in good repair and for maintenance of for public safety.
And did you consider the intent and purpose section of Chapter 8 relative to nonconformities?
Yes, I did. The purpose and intent of that chapter of Section 8 is to regulate and limit the continued existence of uses, structures, lots of records that do not conform to the provision of this of the UDO.
And did you consider the context of the word modification in Section 8.2.6A5 and its consistency with surrounding and related provisions or language within Chapter 8?
I did. Within Section 8 refers to intensification, enlargement of a nonconforming use. And my determination was that adding amenities such as a pool, such as a snack bar, that would increase the intensity of a nonconforming use. And so I interpreted that modification would not include anything that would add to the intensity of the use or prolong the life of.
Or cover additional land?
Or cover additional lands, yes.
And so then there are some things you indicate in your determination letter that you believed would be allowed from your interpretation of the word modification. Is that correct?
Yes.
And what are some of those? What are those things?
Existing facilities, the ones that are shown on the plan submitted in 1996 and 1997. Those facilities include the restroom facilities, piers, docks, and bulkheads, camp store, and other recreational facilities that are shown on that site plan could be modified, could be improved, but no new facilities could be added.
So it was
Existing,
structures or amenities on the property, is that
correct. Existing could be modified.
And when you say modified, is that consistent with your statement a minute ago about the provision relative to repair and maintenance?
I believe so.
I don't believe I have any further questions at this time, Mr. Chairman.
Okay, thank you. At this time, I'd like to ask the members of the board if they have any questions for the staff. I know I have quite a few, and so I don't know if you'd like me to go ahead and start. And
Sure.
Okay, so the first question I have is in reading the text of the appeal, the first number one, grounds for appeal number one, which talks of replacement of the pier.
And
Yes.
Mr. Braithwaite, just so everyone is following the same documentation, because I know there's several things. Are you talking about on her planner's report for tonight, the grounds for appeal, or the application for appeal?
On the application.
Okay. Sorry, go ahead.
So the question I have, is the pier itself considered by you to be a non-conforming use or structure or a site feature because you're considering it part of the campground?
The pier that was mentioned here, specifically Pier 8, came into being after, I think, 2016. It was never permitted through CAMA, and it should have been. And so that pier I would consider, because it was not present, going back through aerial photos, we could tell that Pier 8 had come into existence after January 1st, 2013. So that was not an existing structure at the time that UDO became effective. So that pier, I determined that it should not be there.
So I guess you consider the pier to be a non-conforming structure because it's part of the campground, or are there other provisions of the UDO that would cover the pier possibly separately?
I considered that a non-conforming structure on a non-conforming use because it did not exist January 1st, 2013.
Okay.
How many piers are there in the campground?
At least 8, because it was Pier 8, and I think a total of 9 piers, I think, or 9 different water-dependent structures, whether piers or docks, from the CAMA permit applications and site plans that we received.
Has there been an order to remove the Pier 8, being that it was built illegally?
An order, we have asked them to remove it, and the applicant made it part of this appeal. So we stayed any enforcement action on that pier.
So there are no building permits or anything that went with the pier?
No, there are no building permits for that pier. They did receive a CAMA notification, a violation, but then they came into compliance with CAMA after they addressed the CAMA issue.
I have one question, just a point of clarification. Earlier, you were asked if Hampton Lodge operated under any other names. Are they the same campground that is currently being advertised as KO Way, Currituck, Outer Banks?
It's the same location and the same physical campground. I believe probably ownership has changed. But yes, the location is the one that I assume is being advertised, yes.
Can you explain a little bit more your interpretation of Section 8.1.1 of the UDO that speaks to purpose and intent of the non-conforming uses section of the UDO as it relates to limiting the continued existence of those uses, structures, lots of record, signs, and site features that do not conform?
In general, non-conforming uses, they're non-conforming because the UDO has said that they do not fit with their neighboring areas. And over time, these uses, we would like to see them go away and become conforming uses. So the purpose and intent of Section 8 is to regulate and limit the continued existence of those uses, structures, lots of record, signs, and site features. For nonconforming uses, they can continue to exist, but this section does limit enlargement possibilities, intensification, and certain modifications.
So is it my understanding then that the county doesn't want the campgrounds anymore? They want them to go away?
And with the 2013 UDO, the county removed campgrounds as a permitted use. So it would seem that the county wanting these uses to eventually go away.
Did they do the same thing with the hunt clubs? Just curious, same kind of thing, that's all.
If they remove any use from the permitted use table from the UDO, it becomes a nonconforming use. So essentially, any use could be removed.
So is it safe to say that the overall intent of the nonconforming uses section of the UDO is to limit the continued existence of nonconforming uses, and when I say limit, I mean, is it the intent to limit the activities that would result in life extension of that use as well?
Typically, yes. You do allow the modification for life safety to keep everything in good working order, but no intensification and nothing that would add to it, prolong the life of these uses.
Right. So mainly routine maintenance type things and things that address safety issues.
Yes.
Repairs.
Keeping things in good working order would be the typical maintenance.
Right. Okay. Thank you. Anyone else on the board have any questions for staff? All right. Thank you.
So before, oh, I'm so sorry, go ahead.
You had said that there was no evidence of a plat being approved or being submitted. Being this has been in existence 50-some-odd years, is there any evidence that anybody in the county authorities that would be responsible for it went down and said, you are operating without the proper permits, you need to do this, this, and this, otherwise you can't open, like they do in every other business around? If a restaurant doesn't have the proper things in order, then they're not allowed to open their doors, et cetera? Is there any evidence that the county went and said, you're not in compliance with what our rules and regulations are, so you can't open May 1st, April 1st unless you get this to us for approval?
I didn't find, other than the code enforcement issues noted in the staff report and in my letter of determination as it pertained to the 12 lots the 12 waterfront lots that received septic approval, and then the screened-in porches. That was the only enforcement action as far as those specific things in the county's records. I found no other documentation.
Is that odd that we would have county ordinances and county codes, and they've, over a 50-year span, have not been enforced? And there's no evidence of them being enforced?
I can't speak to that.
Okay. I'm asking because I don't know who's in charge of what, but, okay.
I've been here in Currituck for since September of 2015, and we have been doing code enforcement during my tenure here. So prior to that, I'm not sure how things were handled.
The other two campgrounds that are here in the county, do you have plats for them? Are all the codes enforced on them currently? I don't want to put you on the hot seat, but you're in there.
I'm in here. True enough. I can't answer that question.
What should be for Hampton is also for the other two as well.
Right, and if they are coming forward to expand or intensify their use, then we would put them through the same process. But I can't speak to. I don't know. I can't speak to whether all of the other ones have approved plats or not. But if they came forward to do modifications or to do intensifications, or ask for a letter of determination for their number of campsites, we would put them through the same exercise.
I actually do have one additional question. I meant to ask this earlier. On the map that's displayed on the screen, that's the map that you used to determine that there were 234 recreational vehicle lots available on that site. And you made mention earlier about an area delineated on the map that was identified as tent camping. One thing I do not see on that map is a scale, for one thing, and the second, have we made any attempt to delineate what the square footage of that area is that's designated as tent area and apply that to the 3,000 square foot minimum requirement that seems to be prevalent in all of the preceding iterations of the zoning and in the UDO prior to 2013?
We have not done that yet as far as bringing it in and trying to scale that. Eyeballing it, we were thinking perhaps 3/4 of an acre, and then doing the math from there.
Is that a digitized map or is that completely hand-drawn?
It's hand-drawn.
Yeah, so you might not be able to scale it.
So we might not be able to scale it, but we could, we've got very good GIS and mapping people that maybe we can get a ballpark figure.
And is that part of your plan to, at some point, delineate a number of tent sites
Yes.
that would fall in there?
Yes.
Okay.
Ms. LaCicero, as a point of clarification, am I correct in saying that when it comes to code enforcement and complaints, our county views that system as a complaint-driven system and not an aggressive patrolling type system. So when a person makes a complaint, then a code enforcement officer goes out to a site and investigates the claim and makes a determination if there's a violation. Is that right?
Well, I would like to clarify that. We do take complaints, but we also typically try to, at least along the main roads and frequently traveled roads, that we do try to keep a more proactive approach on those areas. And as of late, we have taken a more proactive approach on code enforcement. We still do take complaints and go from there. But I think that it ebbs and flows depending on staff and what's going on in the county, whether it's a hot topic or not.
So it is likely at some point that a property located within the county may never have a code enforcement officer drive by it at some point.
It's possible, I suppose.
Thank you.
All right, does anyone else have any?
Yeah, I do have one question related to the, shifting gears to go back to the pier. Does the county have jurisdiction in the water, or does that fall strictly to CAMA and the Corps of Engineers? In terms of building a pier that juts out into the water, once you get into the water, does the county have jurisdiction in terms of those structures?
We work with CAMA on those. CAMA would permit those, and then our building inspectors would inspect that.
So they have basically given you the authority to inspect after they've approved them?
Yes.
And the pier that's in question, the other piers, they're used for fishing and launching kayaks and family fun kind of things?
I would assume so, and that may be a question more geared toward the applicant. I've never, other than in my capacity in the planning department, I've never gone to Hampton Lodge and to recreate there.
Mm-hmm.
So
Either have I.
So I would assume so, as a campground, that's part of their amenities and part of their attraction.
Okay.
Okay. Anyone else on the board have any further questions for staff?
Okay, and prior to dismissing her, we would need to give the attorneys an opportunity to cross-examine her, and then we'll circle back to Mr. McCree if you had any follow-up.
Okay. All right.
So I would start with Mr. Mullen.
Johnson.
Wait, Mr.
Anyway,
Johnson.
I'm
Yes,
Tom Johnson
looking
with
at
the
your-
law firm of Williams Mullen, so it gets
I'm looking at his
confusing.
name
So,
tag there. Okay.
But I'm representing the applicant or the appellant. Ms. LaCicero, I have a couple follow-up questions from what the board said and what you said. Isn't it true that a non-conforming use is a use that may have predated any zoning ordinance but still be allowed to remain in effect because it was in existence before zoning ordinance was adopted, correct?
Yes, it could be in existence prior to a zoning ordinance becoming effective.
Correct, and it doesn't make it in violation that you would issue something for it as long as it complied, was in existence before the ordinance.
And continue to operate, continue in its regular existence without any expansion, intensification. Yes.
Right, as a general rule.
As a general rule.
As a general rule.
Mm-hmm.
And now, in that regard, I go back to 8.1.1, which talks about the purpose of, and this is the general purpose of, under the nonconforming uses. And consistent with that, it says the purpose and intent of this chapter is to regulate and limit the continued existence of those uses, et cetera. Uses, structures, lots of record, signs, and site features, correct?
Yes.
Okay. But in 2013, the commissioners at that time added a specific provision, which not all uses in the county that were non-conforming have a specific provision in the ordinance. Isn't that correct?
That is correct.
So in this case, the commissioner saw fit in 2013 to enact 8.2.6, which deals with non-conforming campgrounds.
Yes.
And of course, in that ordinance, we've been speaking about provision A5 in there. And the introduction to that talks about modifications to existing campgrounds, not existing structures. As you spoke to, you said existing structures, and that was your interpretation, but I'm looking at A5 and I'm trying to understand that. So that says existing campgrounds, correct?
Yes.
And it also says, going back to the regulatory in 8.1.1, the introduction or the purpose, it does state that modifications, and it also uses the word changes. It says, provided the changes do not increase the nonconformity, and defines that as with respect to the number of campsites that existed on January 1, 2013, correct?
That is how the ordinance reads.
Okay. Now, you said over a period of time, you said the Hampton Lodge was in existence a long time ago, before predating the zoning ordinances, correct?
Yes.
And I think your testimony was also that there were no specific site plans submitted when there were changes in the ordinance. You could find nothing in the record that Hampton Lodge, except for maybe some septic permits, and I also think you mentioned those special event permits that were submitted and approved over the entire period of those ordinances being in effect.
That is correct, other than the 75 for the 12.
Correct. The 75 for the 12 and the special event permits in 96 and 97.
Yes.
So your record didn't find at any time that Hampton Lodge had submitted, or for lack of a better term, decided to submit itself to the requirements of the ordinance, but yet relied on itself being a non-conforming use.
To continue to exist, yes.
And is there anything in the ordinance that limits campsites, whether it be tent campsites or whatever, to 3,000 square feet if you're non-conforming?
Not in our current ordinance, no.
Or it was in the prior ordinances.
It was in the prior
ordinances, but you just said that Hampton Lodge never submitted itself to those requirements, correct?
Correct.
Also, I know the board asked these questions. I wanted to clarify this a little bit. It appears to me from the record, and correct me if I'm wrong, I want to make sure I'm right, that a lot of building permits were issued for Hampton Lodge, even though it was non-conforming over the years, whether it be electrical or septic or whatever it may be, and those were issued by the county, correct?
The building permits, the electrical permits were, majority of the septic permits were issued by the Albemarle Regional Health Department.
But just because that's who's in charge of that, I guess, correct?
Correct.
So there were various permits, whether it be building, electrical, septic, that were issued by the applicable authority.
Correct.
I don't have any further questions.
I think he's trying to work the mic.
I am Tom Nash with the firm of Trimpe and Nash, and I represent the Water Lily Protection Association, which is a non-incorporated group of people living on the island there in Water Lily. The one question that I would have for you is this. I take it in your interpretation of Chapter 8 and the nonconformities, you obviously read that entire chapter as being applicable to the campground. Is that correct? Not just 8.2.6.
Correct. Both the general and the specific, I took both of those into account of that chapter, the nonconforming and the general nonconforming regulations, and then the specific for nonconforming campgrounds.
Okay, and if you were only to read it, that 8.2.6 would be the only portion of Chapter 8 that would affect Hampton Lodge Campground, would it not, I mean, if you look at 8.2.8, which actually deals with discontinuance or abandonment, my point is that Chapter 8, I believe, has to be read as a whole and not just 8.2.6, because if you read it that way, 8.2.8, if it was discontinued for, say, a year, they could still come right back with the same non-conforming use. Is that correct?
Correct. I read it in its entirety.
Okay.
And tried to apply both the general and the specific in my determination.
Thank you. Mr. Chairman, that would be my only question.
Yeah, thank you. Mr. McCree?
Yes, thank you. Ms. Cicero, Hampton Lodge became, I think you testified, non-conforming upon the adoption of the 1971 zoning ordinance. Is that correct?
That is correct. Since
And what was your testimony with regard to the number of campsites you were able to determine existed at 1971?
Prior to the 71 ordinance becoming into effect, we only had septic permits for 6 camper spaces, a trailer, and a bathhouse.
Okay, and
Prior
then,
to 71.
so then in 1975, what was the number of campsites that you were able to determine from at least the county records that were in existence at Hampton Lodge?
101.
And so somewhere between 1971 and 1975, Hampton Lodge Campground then apparently grew from 6 campsites to 101 campsites? Is that correct?
That is the best research, that my best research indicates. It did, yes.
Would it be a legal non-conforming use? Would Hampton Lodge Campground have been authorized under the zoning ordinances at the time to expand or enlarge or intensify its use from 6 campsites to 101?
If they had similar non-conforming language, I don't believe they would have been allowed that until they brought their site into conformity with those special standards.
And of course, you testified they never have brought, the site has never been brought into conformity.
That's the best that our research has shown.
And now it appears that there are 234 campsites and an indeterminate number of tent sites. Is that correct?
Yes.
And yet the property has never been brought into conformity from the 6 to 101 lots that existed during the period of 1971 to 1975. Is that correct?
Yes.
I have no further questions.
Thank you.
I have a couple follow-up just to that. But if the board has it, they're welcome to ask.
Certainly. Go ahead.
First of all, it didn't say how many campsites. You were speaking to how many septic permits had been issued or other permits had been issued. Is that correct?
I was speaking to the number of permits as far as documentation, because that is the documentation in the county record to justify the campsites or to verify the campsites.
Right, but you're just talking about septic permits or electrical. You're not addressing campsites that may have existed that didn't use septic and electrical or at that time, correct?
Correct.
And also you did make reference to the 2013 UDO, and I direct your attention to 8.2.6B1. Which at that time, if this had been a non-conforming campground, it existing campgrounds may not be expanded to cover additional land or area or exceed the total number of campsites that existed on January 1, 2013, correct?
Correct.
So the commissioners had an amended ordinance, and they came into effect knowing that there was these nonconforming uses, but addressed it by saying as long as you keep what you had as of January 1, 2013, you were okay in terms of existing campgrounds, correct?
Yes.
And that's what the ordinance says
That's what the
anyway.
ordinance says, yes.
Okay. I have no further questions.
Mr. Chairman, before we move on, if I meant to ask to introduce the various zoning ordinance or excerpts about which Ms. LaCicero testified during the course of her testimony. If there's no objection, I've got certified copies of those ordinances. Sure.
Are you also introducing the staff report that was with the agenda? or
Yes,
do we need
we'd like to introduce in fact, the staff report. In fact, I'd go ahead and ask to introduce the entirety of the agenda package that the board has received. And then, of course, anything else I'm sure will be moved for admission that has not been yet presented to the board during the course of the hearing.
Okay.
And I'm good with that.
Okay.
Ike, is this just the ordinances over a period of time that Ms. LaCicero was speaking to?
That is the
right?
excerpts of the ordinances from 1971 to the current time about which Ms. LaCicero testified.
Thank you. Thank you. Thank you.
And that, Mr. Chairman, is going to be the county showing.
Okay, thank you. Thank you, Ms. LaCicero.
I got one last question, if I can.
Yes, sir.
The 3,000 square feet per camper space, has staff actually looked at any of the camper spaces?
As far as site visit and,
As far as verifying that we've got 3,000 square feet per camper space?
no, we have not verified that as far as actually on the ground, because the 3,000 square feet was a requirement in the prior UDOs, prior to 2013. There are site plans that have been submitted by the applicant that show some areas designated, some campsites designated as 3,000 square feet, and some that are not 3,000 square feet, and several of the site plans that have been submitted to the Planning and Community Development Department.
Okay, thank you.
Okay, at this time, I'd like to ask the applicant to his case.
Thank you, Lori. Good evening again. I'm Tom Johnson with the law firm of Williams Mullen here on behalf of the applicant. I wanted to do a little preliminary just overview of what we are going to talk about in our presentation. And some of this has already been dealt with, so I'm going to click through that. As Ms. LaCicero talked about, there was an application. I represent the new owner of the campground, purchased it in the summer of 2018, and the new owner needed some direction because the new owner wanted to make some upgrades and changes and things of that nature to the campground, but they needed to know what they were dealing with. And because we were doing basically a shot in the dark, we decided to ask for an interpretation of the two things that are probably the most important to determine the two issues before you here tonight, and that is, what were the number of campsites on January 1, 2013, which the county commissioners, and when they adopted the 2013 ordinance, basically did a reset and said, we're going to look at that. That's our standard. And the other one was 8.2.6A5 that allowed some changes. So it's generally non-conforming law, and the general issue is you don't make changes, or you limit it, or you do the maintenance and that sort of thing. But the commissioners went a little step further here and have an additional provision setting forth some standards with respect to campgrounds, and contemplated that modifications would be allowed as long as it didn't increase the number of campsites on January 1, 2013. So basically 2 steps here tonight. How many campsites in 2013? Then how does that then play into the modification provision that the commissioners enacted? We appealed the decision, the letter of decision in January, and the pier came up because of the CAMA permit, because CAMA looks to the county and says, you have a look at it and give input. Although CAMA issues it, there has to be a consistency between what CAMA is issuing and the county's ordinances. So that's where that, on that Pier 8 came up. The letter of decision never made a decision on the number of tent campsites at the campground. If you look at that letter of decision, it references maybe there was a 3,000 square foot limit over time, but they could not determine, there was not a determination of those number of campsites. You know, things we said, it's been interpreted to mean only buildings and structures. The way we read 8.2.6A5 is it allows modifications to the existing campground. It doesn't say buildings or facilities, and we couldn't find anything where it said that that was where the limitation came from. And basically my client's just looking to do some modernization things to bring things up to code and to be able to be create a more safe and healthy environment, and consistent with the way campgrounds are today. Again, the controlling ordinances, I won't repeat that again because I just spoke to that. So basically, issues on appeal, as I said earlier, 2 things: number of campsites and what modifications or changes are allowed to the nonconformity under 8.2.6A5. And we're going to go through that. We're going to have 3 witnesses, and we're going to go through that by presenting 3 witnesses. One is James Byerly. He's the Director of Development for Blue Water Development, who is the operator for 85 and Sunny, to talk about just what their goals and desires are and why we needed the interpretation. Warren Edis, the president of Quibel and Associates, who's been the engineers on this project and helping developing the site plans, but also did some investigation for us in terms of the various maps and indication of how many campsites are in existence. And then third, John Lucky Pappas. He's the former owner. He's the one that sold the campground to 85 and Sunny last summer. Had owned the campground for over 40 years. And because of the need to establish how many campsites existed on January 1, 2013, and since Lucky's group owned the campground at that time, we want him to go through and explain what that means, how many sites, and that sort of thing to the board. So I'm now going to turn the presentation now over to my associate, Lauren Fussell, to go over this with the witnesses and their testimony about the evidence that we have found in our investigation. So Lauren, I'll let you go forward.
Thank you. As Tom mentioned, my name is Lauren Fussell with the firm of Williams Mullen, and we're here on behalf of 85 and Sunny. As our first witness, we would like to call Mr. James Byerly.
Good evening.
Good evening, Mr. Byerly. If you could just introduce yourself to the jury, to the board tonight, and tell them a little bit about who you are and what you're here today.
My name is Jim Byerly. I'm the Director of Development for Blue Water Development. We're a company that builds RV resort camps and hotels from Maine to North Carolina. I've been in real estate development and hospitality for over 30 years. And we come to you via the purchase of the Hampton Lodge from Mr. Lucky Pappas.
When did Blue Water Development purchase Hampton Lodge?
Last summer, approximately late June, early July.
Summer of 2018?
Yes.
And you're here on behalf of Blue Water Development, and the appeal tonight is by 85 and Sunny LLC. Can you explain the relationship between those two entities?
Sure. 85 and Sunny is a single-member LLC that's owned by Todd Burbage. Todd Burbage is also the owner of Blue Water Development. We set up all our camps that way that the local structure of the ownership is done locally with the local LLC, but the operating entity is Blue Water Development.
And tell the board a little bit about what Blue Water Development does, if you all have other similar type properties, where those are located, what those are like.
Sure. As I mentioned before, we build and operate RV resorts and hotels. We have 6 operating RV camps from Maine to North Carolina. Those camps are in Maine, Virginia, Delaware, and they are usually similar in size to the Hampton Lodge. All of the campsites range from 400 to 500 campsites, some as much as 600 when you include tent camping. We have 5 camps under development currently in 4 different states. All of those campsites will range from 500 to 900 sites. We pride ourselves in being essentially the Marriott of the camping world. And if you've ever go online to see what we do in a product that we put on the ground, it's something that we're very proud of. The communities we work with are very proud to have us there as neighbors and partners. And it's something that the word modernization has been used already, and I think that's the key term here to focus on. What we're trying to achieve is to take the Hampton Lodge forward for the next 30 years, and in doing so, modernizing the camp to standards that all of our camps are used to, all of our customers are used to, getting the type of services and the type of amenities that we would not only provide in our other camps, but look to provide in this site as well.
You talked a little bit about services and amenities in your other campsites. Can you spend some time discussing with the board sort of what modern camping is, what the state of camping is?
Sure. I think someone had alluded to that there was a code violation or a violation of that there were screen porches and things added on to a camper at a campsite, and for probably lack of funding at the remaining years or the last years for Mr. Pappas' camp, things kind of got run down. If you go to our camps, there's an expectation of a level of finish, unlike other camps in the country. We don't permit anything such as adding a screen porch or augmenting in any way the RV or the tent sites. Where we have what we pride ourselves is the cleanest, nicest bathhouses in camping. We also set them up in a way that they have real safe and direct access to the campers. So being able to have those facilities near the actual camping, we try to have them within 400 feet of every campsite. So you're not walking in the middle of the night, across the camp to use the facilities. It's also the number of facilities that in the bathhouses. That's important that you're not waiting in line, and that it's a modern camp. It's not something. Even the high-end camps of 20 or 30 years ago had limited bathroom facilities, and it's just like you would go to a stadium, 10, 20, 30 years ago. The standard that people are used to these days in terms of safety and the expectation of access is different, and we provide those in all of our camps. A pool is something that is common to not only our camps, but pretty much every camp you go to. A pool is not an unusual event in camping life. And then, obviously, we have recreational areas along with pools, splash pads, anything a family would enjoy, recreational parks, and those types of things.
Mr. Byerly, we've talked about some modern camping. Has camping changed, or has there been a sort of resurgence of camping lately?
The camping world is exploding in terms of who's camping and who's attracted to it. It's also changes the nature of our product mix that we offer at our camps. We're offering not only people to bring their RVs to our camps, but we actually now purchase brand new RVs that are sitting here at the campsite waiting for you to roll up in your car and have the experience of staying in an RV and not having actually to have even drive it. Safari tents are another big product line that we offer, which is, as you might have heard the term glamping, this is something that people love to do. They want to tip their toe in the camping world, but not all the way, so it's a furnished tent. We also supplies park model cabins, which are cabins on wheels, which is essentially an RV, but it's in the form of a cabin. And I have 3 daughters, and that's the type of camping we do. It's an air-conditioned cabin on wheels. So that's the nature of modern camping.
Mr. Byerly, if you'll take a look at the PowerPoint slide, these are some just demonstrative pictures from your other properties. Could you talk just briefly about what these pictures are?
Well, as you would notice, the name of Blue Water Development, all of our camps are waterfront, and water features are a big part of what we do, and not only the views but also water access, as you see in the photo. The bathhouses, as I mentioned, and we're very proud of. Throughout our camps, you'll see stations where you can register happy, not happy. It's a station where the customer can go up and hit a button and say, I'm not happy with the bathroom. I'm not happy with the service at the camp store. That's immediately sent to the manager on site, and it's also tabulated in our offices and in our call center on a weekly basis. So in real time, we can tell what's happening in each camp and what's happening well and what's not happening to our standard. And you'll see that through all of our camps.
And when you say they're happy or not happy with the facility, is that something they're not happy with the cleanliness or the safety?
Yes. So if
aspect?
we see in an hour 10 not happies in bathroom number 3 at our Flat Rock camp in Maine, we know that there's an issue there and it's dealt with in real time. It's something that we do that's unique to the industry, and it really empowers the customer to tell us not only what things are not well, but it's able to us to identify where people are doing their jobs well, and we're told through that system.
Mr. Byerly, can you speak a little bit to the board about the types of campers that you all have at the other Blue Water Development properties and that you all have at Hampton Lodge now as well? And by that I mean the amount of time that they stay at the campground.
Sure. All of our camps have two product lines. It's seasonal camping, which in this county and that site would be 90 days maximum. And then we have short-term campers that are here for the weekend or 3 or 4 days. Usually the camps are a mix of 10-15% seasonal. The rest are transient. And we are very sensitive to the idea and the sensitivity to the community about the nature of seasonal campers. We have no intention in any of our camps that anybody stays past the season. There's no school bus pulling up to our campgrounds. We are very sensitive to that. Matter of fact, one of the first things we did when we took ownership of this site is we worked with the county enforcement to remove campers from our property that were actually residents, that were staying there illegally.
Mr. Byerly, talk a little bit more about some things that you all have done or that Blue Water has done since you bought and have taken over the property. You just said you worked with the county to remove permanent residents from the campground. What else have you all done?
Well, the first thing was really a big cleanup. As I mentioned before, as things kind of winded down for Mr. Pappas, we stepped in as first order businesses. We really cleaned the camp and removed a lot of dilapidated structures in terms of camps and RV camps, campers that were kind of turned into cottages. All that thing, if you stepped out and looked at the camp today, you would see a very clean, pristine camp ready to be modernized.
Mr. Byerly, what sort of modernizations are you all proposing or that you hope to do on the property now that you've taken
I
it
think
over?
what's, as our attorney, Mr. Johnson, spoke to earlier, the things that we're asking for are not uncommon or the norm of what camping and what campers' expectations are when they walk into our camp, a lot of camps, and that's clean, accessible bathhouses and restroom facilities, a pool, an area to recreate, whether it be a baseball field or jungle gym type of swing set. These are all what modern campers expect when they get to a campground.
Let's talk briefly about a proposed bathhouse. I'm going to show you a picture on the next slide. Can you explain to the board what this is?
That's a bathhouse at our Massey's Landing campsite in Long Neck, Delaware. Not necessarily the color, but that model, that building is what we have throughout all of our camps. They're clean, they're well lit, they're accessible, and we try to have them within 400 feet distance to all campsites. And
the new bathhouse facility, what's the purpose of putting in a new bathhouse and additional bathhouses?
More than anything, it's about health and safety, and to to modify what's existing there and to try to create that out of an existing structure, that's not going to meet our standard. We want our standard met to make sure that our customers get the same type of experience whenever they go to any of our campgrounds.
Have you also, are you also proposing to increase the footprint of the currently existing bathhouse on the property?
In order to meet our standards and our customers' requirements, that would be the case, yes.
Okay. We talked about the bathhouse, and you also mentioned that you would like to add in a pool. Can you speak briefly about why you would want to add in a pool?
Well, not only the fact that one previously existed back in the, from our research, there was a pool on site in the late 50s, early 60s. A pool is a standard feature in camping life, in modern camping life, and it's essential to our customers. It's also essential that when what we want to create an experience that when someone pulls their rig into our site or pulls their cart or their tent, they're there for their stay. There's no reason for them to leave. And the more amenities that we create for our campers, the better likelihood we have to keep them on site for the weekend or for their stay.
So a pool, for example, would only be accessible to guests of the campground?
Any of our amenities are only accessible to people staying on our campsite, our campground.
Mr. Byerly, if you'll take a look at these pictures, if you can just describe what these pictures are.
Again, pictures of two different pools. One is from Flat Rock in Maine, and one is from Massey's Landing in Delaware. But that's the type of standard pool that we would be looking to provide.
I want to go back briefly to talk about a couple other of these proposed modernizations. Can you speak for just a moment about a water tank, what that is, why you're proposing it?
Well, in order to service our facility in the nature that we want and create the kind of water pressure and cleanliness that we want, we're proposing as part of the site plan is that we would have a holding tank for municipal water that would essentially create the water pressure needed on our site and not depleting water pressure from the community.
And what about a snack bar? Can you talk about that briefly?
Right. Again, whether it be snack bar, camp store, caretaker's cottage, water features like a pier, all of those things you'll find at any of our camps. Those are things that we consider normal course of business, the normal state of modern camping.
Mr. Byerly, I think the board is aware and we understand that some site plans and submissions have been made on behalf of 85 and Sunny and Blue Water. Can you speak briefly about the intent and the purpose of those site plans?
We've been working with the planning department, for literally almost since we've encountered the property, and it's been, I think someone said, a shot in the dark, and we really appreciate the opportunity to be in front of this body tonight to try to determine what that number is. Throughout the process, we've been using collectively as a group, planning department and us as new owners, numbers to try to get to what is that number. We bought a campsite and we bought a campground, and we have normal expectations that what the acreage here would yield in any other campground, and we expect that those type of matrix or metrics are put into this very event. It's not unusual. It's not out of the question that the acreage that's provided here would yield 600 sites anywhere else at any other camp that we do. And there's evidence as we approach this event to show, as someone mentioned before, there was a 700 unit site plan submitted. So you can see that the property can yield that. But again, we're collectively working with the planning department to get to that number that we can all agree upon. And I think Mr. Pappas would do a much better job giving the historical content as to how we feel that number is appropriate.
Thank you, Mr. Byerly.
Jim, you need to stay up because they can ask you questions. The others will have an opportunity.
I thought it was done.
Okay. Actually, again, I have a few questions.
Sure.
And I'll turn it over to the rest of the board for their questions. So, so the first question I have is, do you have a figure or a total number of visitors that visited the campground in the year 2012?
I do not have that number. I do not. We had very limited financial information from Mr. Pappas in terms of what kind of traffic was actually there. But the one thing I do know is that we interviewed people like the Stargazers who come annually, people that have worked at the camp for years, that there's been many events there over the years where 400 to 500 people were there at any one event camping.
Okay. And I have an additional follow-up question. So the new structures that you are proposing, obviously they do look very nice, and but I have to ask you, what is the purpose of the new structures that you're proposing? Is it to increase the number of visitors at the site?
It's to maximize the experience for the people who use the campground. I don't believe you're doing more camping by being able to use a clean restroom facility, or that you're doing more camping by swimming in a pool.
But you would potentially attract more campers to an upgraded campground.
I think that's the key point here. That's going to happen regardless of what happens from here out tonight. There's going to be a clean, well-run campground that's going to be advertised at that site. It's going to be used.
I think that's all I have to. Anyone else have any questions?
I'm still trying to work through all the names. Blue Water Development, is Blue Water Development also KOA?
I'm sorry, I couldn't hear that. I'm sorry.
Is Blue Water Development also KOA?
We partner with KOA at several of our properties. There is an expectation that this is going to be a KOA. One of the timeline issues that we ran into here is that we certainly made some assumptions back in July, and again, I'm not being critical of the planning department, it's just the fact is what we're up against, that in July we thought we'd be in the ground and being able to be a KOA camp opening this coming season. When we submitted our letter of request for the letter, or sent our letter of determination in August, we got a response in January. So based on the timeline, we'll be opening Hampton Lodge as it's currently configured for this season, where there's no way we can, no matter what results we get going forward from this body or others, that we will operate as a cleaner, organized, managed facility, but pretty much as is going into this next season. It will not be a KOA camp going into this season. We have expectations to be a KOA camp the following season.
Okay. Is it your assertion, I guess, that under 8.2.6 general standards, modifications to existing campgrounds are permitted provided the changes do not increase the nonconformity with respect to the number of campsites that existed on January 1st, 2013? Are you reading that you can essentially build whatever you want as long as you don't expand the number of campsites?
Correct. Why is that language there if we couldn't use it?
Okay.
The question that's before all of us is what's the number of campsites on 2013? Once we decide what that number is, we won't exceed it, but we can amenitize it without expanding that number.
Right, and how are you determining that, the total number of campsites?
The total number of campsites, well, as a starter point, when we took our first look at the camp, there was 280 full hookups on that camp. There's a minimum number starting there.
Okay.
Then we look at the rest of the evidence that you begin to see tonight of 700 sites. So it's some number between 280 and 700.
Okay. That's it for me.
So I'd like to just kind of follow up with that question. The upgrades that you have planned for this campsite or this campground, in your opinion, how do they conform with Section 8.1.1 of the
Once we
UDO?
determine the overall number of campsites as of 2013, and as long as we don't exceed that number, we can amenitize the campground to be a modern, safe place for people to camp. And that includes expanding restroom facilities, offering a pool, which is a normal course of business in camping world.
So is it your contention that the overall intention or the intent of the of Chapter 8 as a whole is not to limit and phase out these types of activities versus enhancing and improving those activities?
I've spent a lot of time dealing with nonconformities in many jurisdictions. What's unique to this and what brings us here is the additional carve-out that allows for amenities to be, or modifications to happen as long as you don't exceed that number.
Right, but modifications.
If that wasn't here, we wouldn't be talking.
But modifications in Section 8.2.6 are not defined. And when we look at modifications in the context of the entire chapter that speaks to regulating and limiting continued existence, encouraging routine maintenance, minor repairs and maintenance that do not extend the life of the facility. That's kind of a broader. Those words I do believe have some meaning as they pertain to the word modifications.
I think we could be both correct in that the thing that we seem to be steering away from is the language says campground. It doesn't specify facilities or structures. It's a modification to the campground. And it's not, if we were saying we're going to build a nightclub there, we're going to build a medical facility, we're going to build things that aren't consistent with normal camping life. That's all we're asking to put there. A pool is not inconsistent with a campground in terms of you want to look at the modification to a campground. It would be unusual. We would be out of the norm not to have a pool. We would be out of the norm not to have safe, clean, accessible restroom facilities. To me, that is not a large modification. It's the norm. And I think we're saying similar things. If the overriding chapter spoke to us changing the campground in a way that was not similar to other camping facilities throughout the country, I think that's where that's headed. What we're saying is we want to have a modern, safe camp that's consistent with other modern, safe camps anywhere in the country. And that language, that carve-out, allows for that event to happen.
And I'll ask one last follow-up question. So is it your assertion that the upgrades would or would not extend the life of the campground? And second, would those upgrades increase the number of visitors potentially to the site?
Todd Burbridge, the owner of the company, is 45 years old. He's a young man that's going to own this property for quite some time. It's going to be clean. It's going to be advertised. It's going to be used. And what we want to make sure is that the people who come and use it are offered the same type of amenities that you would find at any of our camps, but also a lot of other camps in the country that we believe aren't run as nice as we do a good job as we do, but they offer a pool. They offer clean and safe restroom facilities. And the key thing here, and I think, the point that I think has to be absorbed here is that allowing those things to exist ensures that the people who visit the camp stay there while they're here to use it. And it's also important to understand that those amenities are not offered to the public. It's only to the people who use the campground.
Yeah, thank you.
How many acres is Hampton Lodge? How many acres?
I believe it's 185. I think overall. I apologize. I should know that off the top of my head. I don't. It's in Warren. 450. I think I was. Yeah, sorry, different camp.
The bathrooms that are there now, I take it you want to replace them and upgrade them. Can you give us a time frame as to when they were most likely built? Back in the 70s, perhaps? 80s, like, 90s?
And this is not to be critical of Mr. Pappas.
No, not at all. Not at all.
They're unusable.
I noticed that yours have doors on the showers.
Yes.
That was clear. Most campgrounds don't. They have.
Right.
Be lucky if you can have privacy.
It's the single biggest, in our management meetings on a daily basis during the season, bathhouses, facilities, cleanliness, and those issues are talked about every day.
How many campsites total are you looking for?
I'm sorry?
Campsites, how many total are you looking for?
I think that this body together and with the Planning Commission, I think we're looking for a determination between 280 and 700. To answer your question, and if every
And
every
if I
other
could just interrupt briefly, and I'm sorry, there's a lot of conversation in the audience, and I know this is a very emotional topic for a lot of people, and we're talking about near people's homes, but the board is trying to hear what is being said and is being recorded, as well as the attorneys. So, Mr. Chair, you, in your discretion, do have the ability to request the public to remain quiet and respect the proceedings that are going on. And so, if would just ask the audience, please keep your comments down, and so the board can hear everything that's being said, because it is very important. So I just wanted to say that it keeps getting a little loud. It's hard for me to hear, so I know it's probably hard for everyone else to hear. So
Right.
I just want to interrupt on that.
Thank you, Ms.
And
Womble.
I'm sorry about
Appreciate
that.
To finish that thought, and thank you for that. Thank you. The acreage that exists here would yield at least 600 sites anywhere else, and that's an expectation that we have.
Okay, thank you.
Good evening, Mr. Jim.
Byerly.
I have two questions for you. One, is it true that in the recent past, the Hampton Lodge Campground has received violations from the county of Currituck for illegal work being performed on the property?
Not to my not to my knowledge.
My second question to you is more of just a business-related question. Is it normal business practice for a business to purchase land when they do not know the total number of possible campsites and RV sites and spend lots of money on purchasing the site without knowing what their return on their investment might be when they make that purchase? Is that normal or good business practice?
When I looked at this site back in September of 2017, I saw a 400-acre site and reached out to Tom Johnson and began to look at what it is that existed in terms of this issue of the number of campsites. The evidence was overwhelming that we had 280 to 700 sites here. So we made several performers based on several different scenarios. So to answer your question, is it unusual? This is unusual, but the site provides such unique experience, we believe, for our customers and our new customers, and the fact pattern that exists not only with how the code is written, but also the evidence of what preceded it and the nature of camping that went on for generations, that we felt comfortable moving forward.
And as a follow-up to the last question, is it normal business practice to purchase a campground that is currently known as non-conforming?
It's hard to find a campground anymore that isn't non-conforming. Campgrounds are mostly non-conforming now, so we're used to dealing with this issue, and we're really used to dealing with the evidence that was presented to us through this process, and feel very comfortable where we stand.
Thank you.
Any further questions from the board? Okay. All right. Mr. McCree?
Mr. Byerly, in the course of the due diligence prior to purchasing the property, did you or your company representative speak with county planning staff?
Yes, we did. I did.
And you were informed at that time that it was a non-conforming campground, is that correct?
Well, what we were informed and learned that the campground existed before there was any zoning code. So essentially, we purchased a grandfathered site.
A non-conforming site, correct?
Yes.
Yes. So you knew prior to buying it that this property was non-conforming and did not meet the county's ordinances, nor was it allowed as a principal use in the county. Is that
Yes,
correct?
we also knew there was 280 full hookups on the site.
But not 700.
We also saw evidence of site plans of 700 that were submitted to the town.
You saw site plans submitted. Did you see site plans with 700 lots that were ever approved by the county?
Again, what we found here, and again, not being critical of anyone, that there's a lot of questions as to what the end answer is to almost all of this. I think that's what brings us here. And what we're confident in is that when you have a 400-acre piece of ground, you've had camping existing there for 40 years, we have affidavits for people who were at events where there was over 400 people there, that there's people like the stargazers who come there on an annual basis and camp anywhere they want to on the property and have done so for 20 plus years. That's the evidence, that's the due diligence I did.
I appreciate what your company would like, but my question was, did you see evidence that any plat was approved that showed 700 campsites?
No one has been able to present to me that we saw a submittal for 700. There's a question as to whether there was ever a bond posted. We haven't investigated that to its full extent. That's what I took in, is that there was supposed to be a bond presented to secure that.
Well, you heard Mr. Cicero's testimony, didn't you?
I did, but I also heard that there's an incredible amount of corners and dead-end streets to the fact pattern here. There's no consistent fact pattern at all, but we are consistent, is that Mr. Pappas, for 40 years, was there, and it's undeniable what he experiences for 40 years of use of that property. And I think it was brought up earlier as without contest, without anybody questioning its use for generations. That's what we bought.
And isn't it also undeniable that there's never been any use permit issued for Hampton Lodge Campground, or any plat approved by the Currituck County for campsites?
And why would he have had to have presented that if he pre-existed the zoning code?
Then I don't have any further questions.
Any?
I have
Mr. Nash.
Okay,
question,
Mr. Nash.
Chairman. Mr. Byerly, I want to understand your position here. Is it your position that as long as you don't increase the number of campsites, you can pretty much put any improvement in there?
I want to be very specific here.
Please do.
The outline that you see up here is what is in all of our camps. They're not open to the public. There's no nightclubs. There's none of the things that I've read that's being circulated through the community, I guess, to scare people as to what we do and how we operate our business. And there's nothing that would be presented here that wouldn't be happening in any of our other camps that are consistent with family camping on a modern scale.
So is it your position that you can pretty much do anything as long as you don't increase the number of campsites?
Well, I think you're asking that question so I can scare the audience. Anything is a very open-ended question. How about you?
Well,
Can you
I
be more
mean,
specific?
you've got if you have a basketball court, well, can you make it a gymnasium?
We don't have gymnasiums at our other camps. I think it would be unusual for us to present that here. A basketball court? Yes.
So can you make a camp store? Can you increase the size of that?
To make it accessible and modern? Yes.
Make it a Walmart?
See, now, this is why the room's crowded. When you say stuff like that, it's not what we do anywhere.
All right. Well, let me ask you this.
He's doing you a disservice.
I'm sorry. The
Go ahead, continue.
UDO defines the word expansion. And I'm going to read it. It's an increase in the size of an existing structure or use, including physical size of the property, building, parking, and other improvements and structures. Now, it's true, is it not, that your proposed bathroom facilities, swimming pool, and pool house, as you so elegantly placed up there, would in fact be an expansion, would it not?
It would not. As the code reads, the campground can be modified as long as we do not expand the number of campsites. Once we zero in on what that number is, then the modifications that are consistent with normal modern camping life is what we will pursue.
My question was, would those bathroom facilities, swimming pool, and pool house, would that not be an expansion as I just read to you?
If the carve-out didn't exist in the code to allow the modification of a campground, you'd be correct. But the problem that you have here, sir, is that language exists.
Would the bathroom facilities, swimming pool, and pool house not be an expansion, enlargement, and intensification of a non-conforming use?
The use is camping. I'm not doing more camping because there's a swimming pool. I'm not doing more camping because I can go to a larger camp store. The intensification that you want me to, you've asked it three different ways, sir. It's not based on how the code is written. We can modify the camp as long as we can agree on what the camp number of campsites were as 2013.
All right. So is it your opinion then that 8.2.6 stands by itself and the rest of that Chapter 8 doesn't apply?
Well, I think what you would like to do is read that without the carve-out. I choose to read it with the carve-out.
So if you do read it with the carve-out, then 8.1 and others would be applicable, right?
Why is the carve-out there? There was a contemplation at some point when someone wrote that said, we're going to treat this differently. I've dealt with nonconformities in many states at this point in my life, and the nonconformity issues come to expansion when you expand outside the footprint of the acreage, or that's what most nonconformities talk to when they talk about expansion. What this specific carve-out does, it zeroes in specifically on campgrounds, and it doesn't say structures, it doesn't say pools, it doesn't say anything. It says modifications to campgrounds can happen as long as the number of campsites does not increase. I couldn't be any clearer. Again,
all I'm trying to do is make sure that I understand your position is that the other 8.1, 8.1.3, they don't apply. Is that correct?
I think what you're trying to do, sir, is get me to say something that would have this audience think that we want to build a Walmart on the campground.
Let me object.
That's just not the case.
Just a minute, Jim. It seems to be going over and over the same thing.
If
you want to argue the legal point of it, that's fine, but it's asking the same thing about 20 different ways.
I'm just trying to understand exactly where he's coming from, but those are all the questions that I have, Mr.
Yes,
Chairman.
point taken. I think the points have been made at this point.
Thank you very much.
All right, any further questions?
Yeah, I got one more. Back to 8.2.6, existing campgrounds. Existing campgrounds may not be expanded to cover additional land area or exceed the total number of campsites that existed January 1st of 2013. Is it your assertion that the first part of that statement doesn't apply?
To read the first part again, sir.
Existing campgrounds may not be expanded to cover additional land area.
Correct. I think that we're not going to expand the acreage. There's a specific acreage there.
That's your interpretation, that it
Well,
purely
yes,
means
because
land
if you
acre.
read further into the ordinance, it drills down into the number of the campsites.
Right.
It gets more specific.
Okay.
And I would like to just add one further thing. So I do believe that all of the provisions of Chapter 8 apply, and I don't think you can really carve out a specific section without reviewing it in context. So Section 8.2.3 of the UDO states that a nonconforming use shall not be enlarged, expanded in area, or intensified. How would you define intensified in that context?
I would define intensified is that if we expanded the number of campsites as of 2013.
That would be enlarged. But how would you define intensity?
In this specific case, it's based on the number of people, the availability for camping. And as of 2013, there's a number that we're all trying to wrestle with and get to, that if that number's exceeded, then there's more camping. It's intensified.
Okay, thank you. All right, I don't have anything further. Anyone else? Okay, thank you.
Thank you.
Mr. Byerly, you were asked earlier about what you expected when you bought the property, about the number of hookups, but did you also expect when you bought the property that camping would continue to be done on the property that did not involve some sort of metered utility hookup?
That's the nature of camping. Campers come either to hook up, tent camp, or boondoggle is the term, just pull their rigs into any part of the camp where they can just use their own storage in vehicle storage. That's been going on that site for 40 years.
Is there also rough tent camping that went on?
Tent camp, yes.
And do you all intend to continue there, allow to be rough tent camping?
Rough tent camping, traditional RV camping, boondoggle camping, which again, I think that's one of the things that nobody's really, and I appreciate you reminding me of that, because that's a big part of camping. People who roll in, especially with rallies, with the stargazers is another great example. They go all over the campsite to where they can see the best stargazing.
Thank you, Mr. Byerly.
Okay, but before you continue, I just want to take a second to remind everyone to please try to be cordial when we're conversing with one another. I know this is a very emotional issue, and everyone has a stake in this, so I just want to remind everyone that, please.
Thank you. Thank you, Mr. Chairman. We will.
We would next call Mr. Warren Edith. Mr. Edis, if you could just introduce yourself to the board here tonight, describe who you are and what you do, and a little bit about yourself.
Sure. My name is Warren Edis. I'm the president of Quibel and Associates. We're a local civil engineering, environmental sciences, and surveying firm here in Currituck County.
Mr. Edis, could you describe a little bit about your education and any certifications that you have?
Sure. I'm actually a professional geologist. I've got some other certifications, but I've been working at Quibel in a capacity as project manager and coastal development. I've been here since 2003. Worked on several small and large coastal projects that involve CAMA permitting, zoning issues, and we have civil engineering at our shop and also surveying. And so we've performed all those services to come into this property. We do a lot of the front-end surveying and site work, a lot of the design. We don't do any actual construction.
And what what amount of education did you have to become a professional geologist?
Well, I've got a 4-year degree from East Carolina University majoring in geology, and then I had to study or work under a geologist for 5 years and then pass a series of professional exams.
And how long have you been in this field of land management or site management? How would you describe that?
Coming on 16 years now.
16 years.
Yeah.
And what is it exactly that you do at Quibel?
I wear a lot of hats. I'm the president. I'm also one of the staff geologists. I do a lot of environmental science. I delineate wetlands, secure CAMA permits. I deal with boards. So we look at zoning issues. I'm a cheerleader. I push projects along, and so I get involved in all aspects of the project. Overall project management, client interface.
And do you have an estimate of the number of site plans that you've created in your 16 years?
Well, I've been involved in. We have in excess of 120 projects a year. Each one of them does not require a site plan, but probably 60 to 70% do. So let's just say half of them did. 50 times 16, and I'm a geologist. I'm not a mathematician, but
nor am I.
Hundreds
Hundreds of site plans.
Yeah.
We would at this time tender Mr. Edis as an expert in site plan project management, if that's acceptable.
Is there any objection?
No objection?
No objection.
Okay.
Mr. Edis, there was a question earlier about the amount of acreage on Hampton Lodge Campground. Can you answer that for the board? How many acres the property is? Yeah,
I won't get too exact, but around 450 acres by current survey.
Okay. And Mr. Edis, if you'll turn to under tab 2 and the same for the board, there are a number of historical aerial photos. Could you identify those for us just briefly?
Sure. Do I need a booklet or should I just watch?
I apologize. You do. Do you want me? Oh, sorry. If you could, sorry about that. Under tab 2, there are a number of photos. If you could look through those and identify them, I have them on the screen as well. If you could just describe what these are.
Sure, and just as a little bit of context, these are historical aerial photos that we requested on behalf of Blue Water through a Phase 1 environmental site assessment that I personally conducted. And these are aerial photos from various sources that show the subject track. The first one is from 1952, and you can see the brightest white line that kind of comes at a 45-degree angle towards the bottom and left of your screen. That is the location of a. Turn this way. I believe that's where the channel was dug. And you're on the 61. There was the previous slide that I was referring to. There we go. Okay. So now we've lost that place marker, but you see the bright farm fields, and then as you progress, you see sort of an angled dirt road, and that's more or less where the property boundary begins. And so it proceeds all the way to the end, and this is the tip of what we call Church's Island, and then that's Goose Castle that curves around. And it's important to note that at this time the property was probably in excess of 500 acres. Over the years, with different surveys, the acreage has gone down, and that's because the shoreline is eroded, water levels coming up. So probably more than you needed to know there.
And I'll just flip through these quickly. Would you agree that these aerials are all just of the property throughout the years?
Yes, and this one's from 61, and it shows the channel has been excavated out to the bay. And that's from the Woodall house. I believe. So yeah, 70. They're all the same of the property, and 77.
Mr. Edis, could you kind of explain again where the property boundary starts from right to left, or the right side of the edge of the picture, and coming back left?
See this? Can you see that angle?
Yep.
That's more or less the property line.
Right.
It shoots off through the marsh.
Right. So that from there going back to the left, that's your 400 some odd acres.
Yes, sir.
And okay.
And there's a tree line here, and in some of the site plans and other items you've seen,
Right.
that tree line appears in its various forms over time. And
Right.
as we go through this series, you'll see where trees have grown and been.
And I noticed probably 3/4 of that property appears to be wooded or wetlands or something of that nature, and that doesn't seem to have changed over the years. That seems pretty constant.
Correct. And we've done a formal wetlands delineation and consulted with the Corps of Engineers and had it confirmed as part of our process.
Okay. Thank you.
Can we back up to, I'm sorry, I thought there was one feature that it was critical, and it'll come in later as I talk about how we came up with some of the numbers, which is what everyone's here for. But the 1973 photo, and you all can see it better on in your map. You can see there's 4 distinct dirt roads that have been cut in. And I just want to draw your attention to that. When we get into some other items, that'll make a little more sense. But those match up with this what we call the Woodall subdivision that was performed by John Serene. It was 766 3,000 square foot lots, and those roadways were, I'm not sure who put them in or what the origin of them was, but that's kind of how we did a lot of overlays, and we put those plats on top of these aerials, and those cuts match up with some slides we'll show you here in a minute.
Mr. Edis, you started talking about my next point. You could just describe briefly what you and your team at Quibble have done related to the Hampton Lodge campground property.
Sure, and it started back in 2016, and Mr. Pappas had employed a firm out of Virginia Beach, WPL, and they had looked at the site and kind of pulled together some historical information. We took some of that information, did our own research, spoke with the county, had some pre-application meetings, et cetera, and had actually, Ms. Volova had prepared like a timeline of events in the county relative to the project. So we took all that data. We had a copy of the plat that was not recorded, but it appeared in the minutes, in the Board of Commissioners minutes. And we have the ability to overlay these PDFs and other items onto aerial photographs, and looked at these photographs through time. And that's kind of how because it became apparent that this, how many campsites were there. When we first spoke with Mr. Pappas, he said, I don't have a set number of campsites. I've never placed a maximum on it. It was just about whoever wanted to show up. If we needed to run a cord out of the activity center to have somebody that needed electricity, we did it. There were some formal sites, but wherever you could put a camper or a tent was fair game. So as we were moving through this process where he was trying to sell the property, this whole idea of, well, how many campsites are there came up. We were asked to help try to come up with some numbers. And so we didn't just look at one piece or one plat, but there exists this Woodall subdivision plat, and it's based on a 3,000 square foot lot.
I apologize for interrupting, Mr. Edis. I was just going to let you know and the board know it's behind tab 7 if you want to take a better look at it in the picture. But if you could describe what this is and the number of sites that it shows.
Yeah, that's this Woodall subdivision plat, and the main, if I could use the pointer again, because it's. So just for reference, the gate is more or less here, the entry to the property, and so this is wider than the existing gravel road, but it's more or less, it coincides with the main entry road. These parallel lanes are the paths that you can see on the 73 aerial. What we did is and actually WPL did this before us, we reproduced it to see if we could reproduce the same thing, but we built on their work. And if you overlay these, using those general parameters, it actually, when you scale it up, it fits right onto an aerial. And it's, the waterfront is actually kind of peels around this part. So this doesn't include the existing waterfront. And what we did is we took this, because it's, in the ordinance we saw that, 3,000 square feet was kind of that's how you defined where a campsite was. So these are all 3,000 square feet. The store and the activity center kind of fit in there, mostly the store. I think the activity center might actually have encroached in a couple of lots there. But if you added the two, I forget what the exact number was, but it was 234, 236. But if you added that to the 439, that's where this number 766 comes from. It's not fake. It's taking this plat that was presented to the Board of Commissioners and overlaying what was already understood to be there. And I concede that this was not approved. You've all heard about what the minutes said, so I'm not telling you that anything other than we were tasked with coming up with an idea of how many 3,000 square foot campsites. And it was our understanding that a campsite, the criteria was that it had to be 3,000 square feet. I don't know that anywhere in the ordinance, and perhaps we'll dig through and find something, but I don't know that there's a requirement for any utilities. I haven't heard that in anything I've seen or seen that anywhere. So we took that as, well, there's 3,000 square feet, defines the campsite. We took that overlay, we put it on there, and 766 campsites fit. When we did some things to kind of modernize that, if I'm skipping too far ahead.
Mr. Edis, I think I can help you out a little bit.
All right. I don't know how to change the slide.
That's okay, and I'll submit to you that the next two slides are just that Woodall plat separated into two slides.
Yeah, that's where I was going.
Describe what this is, and
can I use that again?
You can, and for the board, this map is under tab 8
so,
of your notebook.
Again, for frame of reference, the Woodall plat, and these are those dark. These are kind of the light black 3,000 square foot lots. Those are the paths that show up in the aerials. You can still see them today if you go to the site. And then these color-coded areas are where trailers were at the time of this study, and where it was, in various check-in maps. This is kind of where we understood people had their trailers. But we also understood that there was this potential. And so, when we were asked to come up with a number, we didn't say out of the gate, well, it's everywhere, because we looked at it reasonably and said, well, we've got wetlands, and we're not going to put RVs in wetlands. So that clipped a few spaces down in the corner. Obviously, there's some areas where trees have not been cleared or they've been allowed to grow up. So they didn't appear to be used, and mostly those are areas, there's the denser trees in this area. These are more sparse. This area was allowed to grow up down from here down. This is the area called the cedars, which there's still a lot of area for trailers and tents, and it's pretty well documented that that's been used for camping. But we sort of backed out these areas because we felt like we looked at it a lot of different ways. We also looked at it from different, we had some attorneys working with us at the time that said there was some case law that, you know, you shouldn't clear new land to say that was where you could put RVs. So when we were asked to come up with a number, and we came up with roughly 408 3,000 square foot lots, plus some of the existing lots, which weren't quite 3,000, but they already exist. They already had utilities. They had campers on them. So we came up with 408, and then we put a number of 50 on the tent sites. And so when I believe I submitted a letter to Ben Woody, I can't remember the exact date, but we were kind of having this discussion with the county. They were saying, well, what, you know, we don't have, you know, we go through our file and see what we've got, and then we were looking at all this evidence. And so that's what we came up with, was 408 RV sites and then 50 tent sites. And we're not saying that there's that much electricity, there's that much sewer, there's that much water. We're saying that there's that many 3,000 square foot sites, and so there's that many opportunities if you know, looking at it in that manner. So that's what we were asked. That was one of the things we were asked to do. We also did an ALTA survey. We did the phase 1 of phase 2, and just and we've been working subsequently trying to come up with site plans that. You know, at several points we've been trying to compromise and come up with scenarios, and then we got the letter of determination. So we've been. It kind of brings us to today.